I to są i które dwa?
Znaczy to jest moja, ale nie moja.
To?
Nie, jakiś świetny.
No, schowamy to dla dziadków. Dla dziadków. I szczepkami będzie można robić. O, no to wszystko jest.
To co jest w gotowi?
Nie wiedziałam.
I was going to find her in this group of people.
Okay, it's 12 p.m., so let's start. It's a great privilege and pleasure for me to chair this session. The papers presented in this part of the conference will focus on the issue of law that was very significant for Malinowski. We're listening to three papers. One will be presented online from Pisa. The first paper will be presented by Professor Mateusz Stępień from Jagiellonian University, and the title of his talk is Lawyers and Sorcerers, Malinowski on Law. Mateusz, the floor is yours.
Thank you very much. This presentation, this talk will be quite different comparing to the previous one, mostly because my perspective is quite different. You will have a view from the legal academia. So I will try to make some reflections and some points about how Malinowski understood law. But I'm not anthropologist, so my perspective is quite different. I'm looking at. I'm still trying to read Malinowski through quite different lenses, because I'm interested what is valid, sound in his approach, comparing to what is going on and to what have been developed in legal sciences. So the originality of Malinowski thought is compared to what was done, what is state of art in or within the legal sciences. So the basics, and then I will move to my point. So first of all, it's obvious for you that Malinowski wrote a lot about legal issues, law, although there is mess with terminology, with definition and so on. But not only this one great monograph, but also at least 5 papers were devoted merely solely to the legal issues. The 2 papers published in 20s are almost forgotten. They were published in Nature. These were small pieces. We should also have in mind that he held a seminar on primitive law in Yale. It was combined seminar held by School of Law and Anthropology department, and there are lots of materials from this seminar, non-published, not published, not even rethinked by researchers. And I want to stress also, I think, something important and missed in the literature, because it's a common knowledge that Malinowski, someone gave Malinowski the super classics of Fraser here in Krakow, and this was the spark which inspired him to get into the ethnography and anthropology later. But it's not a full picture, because he had here in Krakow two distinguished legal professors, law professors, which really worked on ethnography of law and anthropology of law. First is Lothar Dargun. He was a dean of Faculty of Law, and he wrote about using of ethnography in legal history, a very inspiring piece. And the second was Professor Streicher, the once president of this university, and he was a friend of Malinowski later, but he was really his master. He was a professor of legal sciences, of comparative law, of German law, and he also published important pieces, but in Polish, about the beginnings of contracts. He also coined the term legal culture a few decades earlier than Friedman in his famous piece. So my point is that Malinowski had a really outstanding figure here in Krakow in law faculty, and due to his familiar connection, it's for me perfectly reasonable to think that Lothar Dargun influenced his thought. But this is idea on the margins. So the next thing is the lack of reconceptualization of Malinowski's legal thought. So he wrote really much about this issue, but there is no attempt to put these ideas into one coherent whole. So I want to do such things here. So the paper aims at presenting what is original and novel in Malinowski's approach to law. I will reconstruct his approach, but I also see some weaknesses. Maybe I will have time to talk about most striking for me missed opportunity inherent is in his general approach, because he developed a really interesting multi-dimensional understanding of law. So he was he really fought with some different direction to put law into the minds of the people, to put the law into the social machinery, and so on and so on. But in fact, I think it's reasonable to put this small pieces into one picture. But at the same time, he was so preoccupied with distinctions, with need to separate some fragments, elements of social organization, that he missed some very important possibilities. For example, he didn't recognize the possibility of magical dimension of law, or maybe it's more precise way of expressing this idea, magic-like working of the law. I think that he was really competent to move forward and propose some really interesting, sound and inspiring thoughts, but he didn't do it. So this reconstruction will be presented by me only from the from the bird's point of view. So I will not provide details but I will give you the main idea. Of course, there is problem of changes in Malinowski's approaches. Also, it relates to the approach to law, and it's obvious that when we read the first book published in Polish at the beginning of the previous century, is quite different idea expressed than in his later works. The main approach is to read Malinowski stressing the psychological factors. I will talk about it for a while, but on the next slides. But I think that there is continuity in some more general assumption held by Malinowski. Ontological and epistemological. He was keen to empiricism, induction, and the nomothetic vision of science, but not in its or their extreme forms. At the end of his career, he was more close to naturalism, but soft and strong anti-reductionism. So he struggled with expressing his ideas. So those inconsistencies, those different approaches. I think he was really struggling with lack of theoretical tools to express some complex vision of social life. So I would like to place this reconstruction, his understanding of law, against this more general, his approach to ontology and epistemology. We can distinguish three dimensions of law, but it's not on the epistemic side, but on the ontological side. So it's really striking that his ideas are in many places close to not separating biological realm and the social realm. So the culture, and his anthropology is science of culture, is consequence of human biology. It's just it's even a quotation from Malinowski. Satisfying primary biological needs creates new specific cultural needs, which are rooted in the symbolic world, but at the ground there are those biological needs, and he linked law with those needs, and this is a quotation. It's not a law. It's not an end in itself, but an instrument for the achievement of the real biological ends within human activities. Of course, he also stressed that law is a way of limiting biological and imperatives. There is tension between those two functions of law, expressing and limiting those biological tendencies. But he directly linked law with biological dimension. The second dimension is social. It's of course important to stress that he, at this point, even at this point of my talk, that he did not propose the coherent theory which would show the connections between those dimensions. He only presented some thoughts which were not coherent, and the narrative isn't well organized. But this social dimension is very highly stressed in his writings. I will provide you only citation about social enforcement system, which he treated as something similar to law. Let me provide this quotation. Law, in the sense of the socially established rule, I mean a command on a rule of conduct sanctioned by the organized constraints. So he put the organized, structuralized ways of sanctioning as a core of defining law on this social dimension. So you can see that this idea is expressed in his first book published in Polish, and those papers published after his death. So there is a continuity in stressing this social dimension of law, but of course there is also the psychological dimension of law stressed by Malinowski in really various places. The social enforcement system cannot exist without some complementary acts of human consciousness, motivation. Something should be taken into account which is happening inside the human minds. So in the Argonauts, he wrote that thinking about norms, external social machinery, always should cover views and opinions, ideas, feelings, and impulses. And in this category, we should put his famous definition of law expressed in his monography law about custom and crimes, stand out from the rest in that they are felt and regard legal norms as the obligation of one person and the rightful claims of another. This is this famous unnoted reference to work of Petrarzycki. It's quite similar definition as psychological definition of Petrarzycki's, and we should integrate those three dimensions. Law is multi-dimensional, bio-social, psychological phenomenon that should be examined on all these levels. We can put this into this simple graph, but still there is no theory about these three layers. There is only a vague idea that we should look at the law at those three places, but there is no any kind of sophisticated theoretization about this. And the last idea, the last thought. You can see 8 features of Malinowski's legacy in understanding and studying the law, and I scientifically was growing up in Krakow, and all those features are something as normal as air for me. It's something which I breathe all time. So rejection of pure speculation, recognizing that science should aim at building theories that primarily explain some area of social world, searching for factors determining the law, interest in the real functions fulfilled by law, looking at the law from the addresses perspective, the necessity to refer to states of consciousness of those addresses to explain the law, treating the law as a multi-level phenomenon, ontologically complex, which should be analyzed in functional terms, and assessing an important place to the culture or legal culture category. Those features can be treated as obvious, trivial, and so on. But I think that Malinowski really established this way of thinking. Maybe this way of thinking having been codified and presented in the coherent way, but this way of thinking really is embedded in how law was and is studied at this university. So I'm in this sense, the Malinowski is my master, because I share all this assumption which could be easily distilled from his legal writings. And I will leave aside the topic on which I'm working. So maybe on another occasion I will have a chance to talk about law and magic, and something which Malinowski didn't do, but he, I think, was really competent to put some more intriguing, more appealing ideas about law. Thank you very much.
So thank you, Mateusz, for presenting us this broad view on Malinowski's concept of law. And now the floor will be taken by Professor Magdalena Krysińska-Kałużna. She will present the paper Bronisław Malinowski and the Limits of Law in Anthropology.
Thank you very much. I will look for my presentation. Just a second. Dobrze, to...
To nie ma problemu. To jest to tak.
Nie. And the limits on the here, the limits of the law. Teraz, przepraszam, czasem głupie strzałkami, ale wystarczy, że nacisnę, żeby się przesuwało tutaj, tak? Tutaj, dobra. Thank you very much for invitation, and I will help myself reading to be able to finish in 20 minutes. Malinowski was convinced that anthropology has an important mission to fulfill, and for that mission to be complete, a general theory of culture and mechanism of human society needs to be created. This theory would allow effective investigation of several areas of culture, including law. The Polish anthropologist, or Polish-British anthropologist, believed that none of the areas of primitive culture was as careless as the law was. Malinowski wrote about what the law is and how it should be examined in texts published over 30 years. However, he did not give a strict definition of this term, although he was demanding from other researchers to do that. His statements on the law bring to mind some kind of shadow game. The law appears in many mechanisms and institutions of culture with which it is associated but cannot be captured. This lack of clarity about what the discussed phenomenon is can be perceived as a disadvantage, but it can be perceived as an advantage too. By maintaining the definition of law ambiguous, Malinowski could more easily reinterpret the concept in his subsequent publications. So what is the law for Malinowski? To answer this question, we need to trace the evolution of the researcher's thoughts about the law, expressed at least in 3 important publications of his: Crime and Custom in Savage Society, Introduction for Hopkins Law and Order in Polynesia, and New Instrument for the Study of Law, especially Primitive. The reader of Custom and Crime learn that the law covers the whole culture and entire tribal constitution of this tribe, of these natives, as Malinowski says, and that the structure of the tribal society is based on the principle of legal status, while the investigation of primitive law is a study of various forces that make order, uniformity, and cohesion in a savage tribe. As Malinowski states, the rules, legal rules, stand out from the rest in that they are felt and regarded as obligations of one person and rightful claims of another. Law is not the rules of the custom to which a native is mechanically obedient. The law is also not just a mechanism for imposing justice in the case of a crime. As he said, the factor of the moment of law, effective social cohesion, is associated with complex devices that cause people to keep their obligations. First of all, among them is the principle of reciprocity, do des, which permeates tribal life. Malinowski also notes that there are rules that should not be confused with the law. The law is presented here in this paper, Custom and Crime, as a specific result of a configuration of obligations as a force that causes obedience. It turns out, however, that this obedience is not absolute. Several pages later, we can read that the law has its perfect forms that are respected or not. If a native can evade his obligations without the loss of the prestige or without perceivable risk of his profits, he does it, exactly as a civilized businessman would, Malinowski says. Malinowski said that apart from the rules, equipped with social power of action, the communities described by him also have norms based on supernatural sanctions. He paid special attention to witchcraft, which in parts of Melanesia he investigated was a means to exercise power. According to Malinowski, the same way suicide was a firm pillar of law and order. In Introduction, which was published in Polish as Law and Custom, published in 1934, Malinowski informs the reader that he's looking for a theory that defines the exact place of the law in the general system of human civilization, that gave precise criteria to determine the mechanism that force people to comply with the law. That would allow to find the most important factor for primitive law and our own law, positive law, we can say. He also immediately declares that he cannot present a pretentious theory of the legal aspect of culture in this, as he writes, a brief introduction. Culture is incorporated into institutions, and law is one of the basic requirements of all culture processes. Despite his statement of not offering an exact definition of law, he calls it an effective custom, once again erasing the limit between law and custom, whose delimitation he demanded from other authors, in particular from Hartland and from Radcliffe Brown. Malinowski also believed that regardless of whether we specify a rule such a custom or law, it's necessary to investigate whether, and now I think it's important, the rule is really respected, under what conditions it acquires binding force, and what are the social mechanisms that enforce obedience to it. I think this is one of the most important thoughts of him on the law. Malinowski was mainly interested in civil law, which according to him should be at the center of anthropological research. Also, as admitted by Andrzej Paluch, the distinction between civil law and criminal law in primitive society was not made very clear in Malinowski's work. Still, this interest of his is manifested, among others, in the text A New Instrument for the Study of Law, especially primitive, that appeared in the Lawyers Guild Review in 1942 and later, after Malinowski's death, again in the Yale Law Journal. In this text, Malinowski expresses his decision to specify his understanding of the law, and as the main postulate, he presents the idea that the term law must be applied in a strictly defined sense. He distinguishes four of distinct meanings. The law as a principle of determinism, for example, the law of science. The law as a norm of conduct, for example, conventions. The law as a regulator of behavior in relations between individuals and groups, including the rules related to property, power, life protection. The law as mechanism that is activated when a conflict occurs or the social rules of behavior are broken. Malinowski points out that this classification is not complete and its objective is to eliminate ambiguity in the use of the term law. What is crucial for him, above all, is the difference between law as a social order and the punitive law that restores the order of social action. The latter is put into action when the version signifying order stops working. He made a very interesting statement by saying that each particular law is determined by the need to preserve the identity of the group. This thought, however, had not been developed by Polish and British anthropologists any further. Malinowski is a precursor and at the same time a debtor towards other thinkers and researchers. He was both when he wrote. We also had the opportunity to propose a new classification of customs and tradition rules, to give a new definition of law as a special class of customary rules and sketching further division into individual types of law within its full system. We would also have to make a distinction between a number of different systems that together create a full tribal law system. Later, this idea was developed by Leopold Pospisil, conducting research among the Kapuaku on the Dutch New Guinea and among the Inuit. However, Malinowski was not the sole anthropologist which could inspire other researchers with a thought about the multiplicity of law systems functioning in one society. While Bronisław Malinowski was conducting research in the Trobriand Islands, Cornelis van Vollenhoven, a Dutch lawyer, laid the foundations for the Adab legal anthropology, Adab Law School. Van Vollenhoven introduced the idea of legal pluralism before Eugen Ehrlich and George Gurwitch, and even before Van Vollenhoven, then there had been Leon Petraszczycki, who postulated the dichotomy of official and unofficial law, as well as positive law and the intuitive law. It should be noted here that Bronisław Malinowski knew the works of both Leon Petraszczycki and Eugen Ehrlich, but did not mention their names, referring to the idea of legal pluralism and the idea of the law as rights and obligations. In addition, as Jacek Kurczewski demonstrates, the idea of the relationship between rights and obligations felt as binding is in fact Leon Petraszczycki's idea adopted by Malinowski. Very often, Kurczewski says, newly proposed theory or concept so obviously fits the needs of other writers and researchers that it is experienced merely as a statement of what they had been thinking already for a long time. The debts that Malinowski incurred were not wasted. He somewhat anticipated the controversy of Gluckman-Bohannan and partly settled the dispute. Both Max Gluckman and Paul Bohannan assumed that, as in the case in Western societies, the law is always a phenomenon that can be distinguished as a separate field. They both used the approach of case analysis, but Paul Bohannan believed that for a sensible description of the legal system of a given culture, it is necessary to use indigenous terminology. Meanwhile, Max Gluckman used Western categories to perform comparative analysis. 20 years earlier, Malinowski wrote in Law and Custom that, so in this introduction, that regardless of whether we deal with contemporary, positive, or primitive law, we should examine the action, not the form of law. The researcher should therefore focus on the function, not on the form. The law in action is important, not just analysis and understanding of norms. It was this mode of thinking that was later adopted by supporters of thinking about law as a process, and in some way by representatives of legal realism, to which Llewellyn and Hubble belonged. Malinowski was very impressed by concept adopted by both the Americans. His research was also certainly a reference point for Llewellyn and Hubble, who, also critical for Malinowski, appreciated his achievements. When we read Malinowski, sometimes more important than clearly formulated concepts and definitions seem these ideas which he did not develop and those questions he did not ask. He repeatedly stated that it is necessary to examine the cultural mechanisms which makes legal coercion materialize. To this end, he postulated an analysis of social relations and, above all, of the relationships that unite one institution with another. He stressed that it is necessary to correlate facts in the field in a precisely specified, detailed, and substantive way, to investigate dynamic relationship between phenomena, and to detect their interdependencies. And also, the perusal of his legal text will likely not yield many of the above-mentioned points of analysis. We can grant Malinowski that he directed many researchers on the route towards realization of this positive and specific work program. Probably, we can't be sure. The writing Crime and Custom, Malinowski states that the law is not a permanent cluster of customs exerting permanent emphasis on the individual. The law grows out of the processes it rules. What is more, it is a result of abrasion of one legal principles with others. The law arises from the processes it governs. It is the result of constant struggle of some legal principles with others. Malinowski declares that more important than to enumerate the rules of the law is to observe how they are implemented and what are the consequences of obeying the law and the consequences of the negligence. Okay. The rules of the law must be examined in their operation in real life. It is then that we learn that its very nature consists of many tentacles with which they are introduced in the context of social life. This proposition is already very close to stating that the law is a process, or that it is necessary to analyze the conflict of norms to investigate the dispute. But Malinowski stopped halfway. This path was walked by Hubble and Llewellyn, the authors of The Chain Way, a book applauded by Malinowski himself. Like Hubble and Llewellyn, Malinowski thought it is not natural or obvious to obey the law. To prove this, we had to undertake an empirical investigation that would show the consequences of its breach. However, the door that Malinowski intended to open to see the law as a process remained only ajar because he restricted its full opening by the assumption that all social phenomena result from the principle of reciprocity. Having had observed that chain life, Hubble and Llewellyn went beyond this dogma. Malinowski posed Malinowski posed questions and identified research problems which remain signposts for legal anthropology field to this day. He did it seeing the beginning of the road in the point or the place from where some other researchers were not going to go anywhere, sitting still in armchairs and watching photos of the savages in the albums. Thank you very much.
Thank you, Magdalena. It was really inspiring talk. And let's move to the third paper. It will be presented by Federica Martiny from University of Pisa. Federica will be connected online via MS Teams. So, Federica, I hope you can hear me.
Yes, can you hear me?
That's great. So, Federica, the floor is yours.
Thank you very much. First of all, just say a few words. First of all, I'm honored to be part of this conference, which is attended by outstanding scholars, and I'm honored to be part of this specific panel session. I want to apologize for not being there with you in Krakow. I had a family problem, but I would have really much liked to be there. So I really want to apologize for that. My paper is related to the two previous papers already presented, and in a way it is also related to what Professor Iwanowicza said yesterday when she presented her paper, The Argonauts in the Western Pacific and the Golden Fleece in Social Life, because she stressed a lot our attention on the idea of trust, connected with the idea of justice as well. So, considering the legacy of Malinowski in the context of contemporary social and philosophical thinking, I want to focus on the subject of primitive law, in the sense that the study of the various forces producing order and cohesion in a savage tribe can be useful for us to do something specific, so to investigate the legal phenomena from a point of view which is not connected with the point of view of Western societies, mainly included. So not in the conventional, let's say, study of law. The starting point of my analysis is, first of all, the idea that Malinowski questions the thesis according to which law is a product of very few and therefore privileged societies. So this is the very first starting point. The second starting point is actually that he was the first to address the related issues of the nature and universality of law, inductively, literally, from the ground up, which is a new idea. This is something that was pointed out by Conley and O'Barr in their paper Back to the Trobrians, the enduring influence of Malinowski's crime and custom in savage societies. And it is connected with a contemporary analysis in legal theory and legal philosophy, actually. So what I'm trying to say is that Malinowski promoted a de-Westernization idea of law. And by doing so, we can compare the position of Malinowski with the position of legal postmodernism, that is critical of the supposed universality of the law and rejects the belief in a stable transcontextual foundations of legal systems. At the same time, I think we can connect the idea of reciprocity that was already described by the previous paper, to the idea of trust as the foundation of law and institutionalized social relations. Here we have to mention that there is an opposed idea that states that behind law there is mainly and commonly the mere fear of punishment. The idea of Malinowski is completely different from this perspective. I want to briefly try to give you an idea of the context of contemporary Italian philosophy of law debate and reflection. For example, a recent book published by Professor Tommaso Greco, The Law of Trust, according to me, can be a good reflection in which we have some space for Malinowski's idea, even if Malinowski is not explicitly mentioned in the debate, because as for example, Mateusz already told us, his legal thought is not so well known in also the legal context and legal philosophical context. So even if Malinowski is not explicitly mentioned in this contemporary reflection on the idea of law as trust, I think that the study of the various forces producing order and cohesion in a savage tribe can help us to understand the phenomena of trust. The phenomena of trust seen as the foundation of the emergence of law in society. For example, I want to give you a brief example of what I have in mind, since this conference is dedicated to Argonauts of the Western Pacific. So in that book, the key of reciprocity can be understood in the idea of the cool exchange. The deep meaning of the cool exchange was to establish social relationship over time. In which way? By creating, in fact, a solid mechanism for maintaining peace in the middle of one exchange and another. So the cool exchange, even in Argonauts, can be seen as a key legal factor in the way it helps the different tribes to maintain peace over time. So now let's go back to the idea of law in some more details. As it was previously mentioned, I want to stress as well that primitive law presented as a functional response with respect to the need to organize human behavior in a cooperative way can be also configured with the famous distinction by one of the legal realists, Roscoe Pound, which made the distinction between law in books and law in action. It is a very famous quotation from this legal realist. And the idea of law in action, as it was really mentioned just some minutes before me, is something that Malinowski stressed as well. We can take Malinowski's reflection also within the reflection of legal anthropology, philosophy of law, legal history, in at least two ways, by comparing it with legal pluralism and legal realism. I want to mention, for example, that Pietro Costa placed Malinowski among the theoretical premises of legal pluralism. For those who are not very familiar with this legal concept, we can just briefly say that legal pluralism refers to the idea that in any one geographical space defined by the conventional boundaries, for example, of a nation state, there is more than one law, there is more than one legal system. So the idea of a multi-dimensional of law, and according to this idea, it is inevitable that the traditional state-centered legal philosophy must give way to a different paradigm. So a paradigm which recognizes the plurality of law. This is something that was mentioned in Mateusz's book, Bronisław Malinowski's Concept of Law. On the other hand, we can compare Malinowski's vision to the legal realists. In this case, Laura Kalma explained the relationship between American legal realism and anthropology. And concerning, the idea of the shift in the perspective from the study of abstract rules to a focus on empirically observable behavior. And again, I want to mention, as it was already mentioned, Llewellyn and Hobel's the Cheyenne Way. That is a great example of the mutual influence between just realism, legal anthropology, and the ability of these two disciplines to mutually influence each other. More recently, Caio Stuori underlined how Malinowski is one of the ties that bind the interaction between American legal realists and anthropologists, with the purpose to criticize scholarly formalism and social and political conservatism. So these are some contemporary contributions I wanted to mention to you. Now let's go back to Malinowski's idea of law. We already heard how the concept of law expressed by Malinowski changed over time. For example, Schapera pointed out the different changes of his distinction, and the main differences about the different perspective from more ancient works and the more recent one is basically the difference between the idea of law as a social norm and the idea of law with a more precise legal definition. For example, according to Schapera, there is the distinction between civil law and criminal law. So even in Crime and Custom, Malinowski argued that what we call civil law as opposed to what we call criminal law corresponds to a system of rules obeyed and respected. But it is in the second phase of his life that Malinowski explains the mechanism behind the obedience of civil laws as emerging from the idea of reciprocity. So as we already heard, the mechanism according to which a certain behavior is considered a duty for one individual and a legitimate right for another individual. In the idea, in this idea, reciprocity is based on the sense of duty and on the need for cooperation. in Crime and Custom, Malinowski proposes a minimal definition of law, what we call a minimal definition of law. Here I'm quoting, in all societies, there must be a class of rules too practical to be backed up by religious sanctions, too burdensome to be left to mere goodwill, too personally vital to individuals to be enforced by an abstract agency. So here we have a definition that implies a distinction between the legal world and the social world. So, for example, we have moral and religious norms which are irreducible to the legal sphere. In the same work, Malinowski continues his exploration of social interaction, for example, by investigating the ritualized exchanges of fish and yams, the so-called wazi, that was taking place between individuals of coastal and inland villages. So the idea of the reciprocity is complex between different communities and different villages. According to Alvin Guldner, in his analysis of the cool exchange, we have to emphasize that gifts given are not immediately returned, and it is required to wait an interval of time. So in this time, we have the norm of reciprocity in a double sense. Here I'm quoting, first, the actor is accumulating, mobilizing, liquidating, or earn-making resources so that he can make a suitable repayment. Second, it is a period governed by the rule that you should not do harm those who have done you a benefit. So again, what I was mentioned at the beginning of my presentation, the idea of maintaining peace. I don't want to mention again his idea and his comments on the Cheyenne way, as they were already mentioned. I can maybe move to another point, which is actually a debate between Malinowski and his colleague Radcliffe Brown, because it is interesting not only the anthropological framework of the differences of perspective between the two, but also more specifically the differences on the idea of law between the two. So, for example, Radcliffe Brown accepted the proposal of the jurist Pound to introduce two variables that Malinowski had not included in his own definition of law. So we are talking about the use of force in coercion and formalized political organization. There was a short, let's say, short debate, which were hosted by the journal Man, specifically in the 35th volume in March 1935. And in this debate, Radcliffe Brown objects to Malinowski a lack of definition of some significant terms that are actually recurrent in his analysis. So lack of definition of a precise definition of terms as law, sanction, primitivist society. And he actually says that Malinowski disregarded and was not interested at all in the meanings attributed to those terms by jurisprudence. So in his reply, in his interpretation, Malinowski's tried to reply to this critique, to be, I mean, insensitive and not interesting of legal definitions. So those definitions used by legal scholars. And for example, he actually says that not only that it was not true, but that basically that was not the point. So here I want to mention something that Professor Antonino Colajanni wrote in his introduction to the Italian translation of Crime and Custom, and he suggested that this rejection of a formal definition of law is not casual. So, for example, that maybe Malinowski wanted to recognize a legal nature in certain social phenomena independently of the existence of external coercion, but on the basis of the internal force of obligation descending from the expectation of mutual behavior of others. And so the idea is that Malinowski's attempt should be read within the framework of a conception of society that seeks to free itself from the idea of the modern world of the necessary relationship between law and state, between law and organization, between law and political power, between law and force, between law and coercion. So the idea of law as reciprocity has a completely different meaning, and what I was trying to briefly say today is that this meaning is connected with the idea of trust, with the idea of thinking to a different basis of justice, which is connected with cooperation between human beings and cooperation within human societies. Thank you very much.
Thank you, Federica, for your excellent paper, and thank you to all the presenters. And now the floor will be taken by Professor Kaja Gadowska, the director of the Institute of Sociology at the Jagiellonian University.
Thank you. So to start off, it is with pleasure that I thank all three speakers for the novelty of their perspectives and for thought-provoking presentations. So on one hand, when we think about connections between Malinowski and law, it is not the first thing that comes to our mind. Malinowski and law, or even Malinowski and anthropology of law. On the other hand, being a sociologist of law, I have to say that I learned a lot from this panel, and I greatly enriched my knowledge of the connection between Malinowski and law. And not unexpectedly, the prominent sociologist of law and anthropologist of law, Jacek Kurczewski, whose book on primitive law I have here with me. This is a book from 1973. So he highlighted that the anthropology of law shares common ground with the sociology of law. And of course, research spaces of those two disciplines permeate one another. But of course, those disciplines are different at the same time. They are distinct. And what is underscored in the literature is that anthropology's distinctive contribution to legal scholarship lies in its unique methodology. And let me quote Fernanda Pirier, in her book on the anthropology of law. She says that anthropologists seek out cultural differences, describing the various and distinctive methods people have developed to organize their social lives and relations. For legal anthropologists, this means examining the structure and operation of legal institutions, right? The ways in which people conduct legal processes, the rules and categories they formulate. And basically, taking all those things into account, it is not surprising that the organizers of the conference saw for our panel the following goal: reconstructing and critical discussing of anthropology of law by Malinowski. But returning to the presentations and to the authors, a few comments and questions come to my mind. Because the issues and the ideas that we heard are overlapping, so I would perhaps not repeat what we have already said, but I would prefer to open a discussion and not to artificially address one question to one presenter and then wait for the answer, but it would be more like an open discussion with the presenters and also with the audience. So feel free to those who are here in presence and those online to join us at any appropriate moment. So the first and most general topic would be how exactly Malinowski resonated in the anthropology of law, in the sociology of law. What can we see in our current theories and in methodologies that are parts of his legacy? And one thing that comes to my mind is our cooperation, the cooperation of the Institute of Sociology of the Jagiellonian University with the Court Watch Foundation in Poland. So we are doing research. We are observing, well, it entails precisely the participant observation of court's procedures. So we are not making any statistical surveys. We are not going to the people with questionnaires, to parties in the courts, to judges, to prosecutors or attorneys at law. But instead, students take part in trials, in court cases, as an audience. So they are observing what's going on there, and this is how they describe the situation. They can see it more deeply, I would say. So what other examples we have in this respect, or more importantly, how else could Malinowski be applied to research in law? And in related matters, but on theoretical level, how has the field of law evolved with respect to Malinowski approach? We have already heard many examples in all three presentations, but considering law holistically and multi-dimensionally, like Malinowski did, what has our academic discipline learned from Malinowski? What we can still learn, or how can we better integrate his approach into our research? What I mean is, how would Malinowski collaborate with such scholars like Petrarzycki, already mentioned here, or Adamson Hebel, or Karl Loewelin? So those are important questions to develop more deeply into the interconnections. His comments on legal pluralism, on legal realisms, and so on. Another question next. What is coming up specifically in Federica Martini's presentation? But it can be, of course, treated more generally. How does the norm of reciprocity function in law, especially in civil law? How does this apply to equivalence of services? For instance, I reminded the Latin saying, "Do ut des," I give so that you give. No, this is a contract which binds both parties, and in fact we have it in Polish Civil Code. It is Article 487, and it is based precisely on this principle. So we have still many examples of reciprocity. And finally, taking into consideration that we are emerging from 21st century pandemics, and we are more and more living our lives in the internet, our social relations, we have those social relations online. We are much more active in social media. How can we apply Malinowski to the words so focused, I would say, on algorithms, on artificial intelligence, on big data? A couple of months ago, one of prominent scholars here in Poland, Professor Dariusz Brzeziński, he was a guest at our institute, and he pointed, of course, as many others, to dangers of big data and especially datification of social sciences. So he noted the paradox that the bigger the flood of quantitative data, the more there is a need for smaller scale qualitative research. So how can we get a thick description of big data? How can we apply Malinowski approach precisely to make use of this data, to understand social processes and legal processes, of course, because it is also an issue of ethics, right? I would say elaborating new solutions, new legal solutions. So let me stop here and invite all the speakers and the audience to the discussion. Thank you.
Thank you, Professor Gadowska, for this excellent comments and questions. So I'd like to ask our presenters, would you please relate to the comments were given by Professor Gadowska? Let's start with Professor Stępień.
Thank you very much. It's you provoke so many thoughts. It's really a lot to digest. But I will try to make some quick response remarks. But these are huge topics. First of all, what could we gain from Malinowski in relation to legal science? I think that first of all, we can be more aware who we are. It's something which is elusive, but I think important. Second of all, I think that we can trace what I named as the air, which is just around there, here, so we can be also more aware about our paths of developments and so on and so on. But frankly speaking, I don't see any direct reference of Malinowski to specific work in legal sciences. Let me explain it in a few words. We can, and I think it's the best strategy, we can pick some idea, some thought, because Malinowski was good in proposing ideas but not developing them. So it's good strategy, in my opinion, to pick up some small idea, some detail, and build on something on these small pieces. For example, what I'm doing now, law and magic. It's not even mentioned in Malinowski's writing. Only few legal realists pick up this subject, but also it was comments, and we can do something referring to Malinowski's ideas, but not as a something solid, stable. For legal scientists, Malinowski could bring some fresh air, but on a general level. It's my impression, referring also to the last paper, excellent paper made by Federica, because she showed that there are some general ideas which are sound, but not concrete tools, concrete conceptions, and so on. Maybe the last remark I will give the floor to others. What is I didn't say it in my presentation because I was focused on some concrete idea, some specific point, but I think that there is a great difference between how we experience law now and how those people who studied Malinowski experienced their law, because for them law was embodied even in the landscape. It's really fascinating because it was related to those myths of origins of sub-tribes and so on. But when Troubriders see the landscape, there is something legal in this view. So we are detached from law, and it changed our consciousness, legal consciousness. So our legal consciousness is something constructed, not embodied to large extent. It's my opinion. It's my opinion. So we could use Malinowski as his works as a device to try to experience different reality, because we can be more close to law. We can build our institution by our hands. We can create legal landscapes and so on. Also, in case of ownership, there is many interesting ideas which could be incorporated, observed by Malinowski, which can be incorporated into our economical systems. It's not distinction between private property and communism, but something in between. So we can try to look for something which has emancipational value for us. I want to stop here.
Okay, thank you, Mateusz. Magdalena and Federica, would you like to share some thoughts with us?
Okay.
Maybe let's start with Magdalena.
Thank you. I don't know if I'm able to add something interesting, but I try. Malinowski didn't give exact definition of the law. It was very broad definition, which was difficult to make a difference between law and social control. But maybe he was right, because I am not sure if I remember well, but I think Hart said that it's so difficult to define law, quoting Saint Augustine, that he said that, paraphrasing his opinion about trying to define the time. Yes, that it's so difficult to define. It's the same way as it is difficult to define the time, it's difficult to define the law. And in Malinowski's works, we can find so many ideas that he just started, and he didn't develop them into one conception. For example, he was observing Yakala. It was a kind of dispute among natives, you can say, yes. And it could be the beginning for paradigm of law as a process, because we have two big paradigms in in legal anthropology. Law as a norm or normative and normative paradigm and processual paradigm. So this processual was using disputes for observing and for trying to define law, what the law is in a society, given society. So it could be just the beginning of this processual paradigm, yes, but this was just an idea. I think that maybe Roberts and Komarov was coming back to the ideas of Malinowski's ideas about so broad understanding of law when they were doing research among the Twa people, and when they decided that maybe we can't talk about legal anthropology and we can talk about something like law which we can extract from the social life, and that the law is in the bottom and is another aspect of the cultural life and social life. It was the same what Malinowski said. There are my comments. And about artificial intelligence, I don't know if I can give a comment, but maybe only this, that is something like machine learning used for teaching and artificial intelligence, and it is that learning through trial and errors, and this artificial intelligence had to gain a goal through this teaching. So maybe it's the same way which people in Malinowski's description are trying, this Trobriand businessmen, we can say, are trying to gain their goals through different strategies, learning from trying different strategies using the different norms which functioning in the society. So thank you very much.
Thank you, Magdalena. I remember a paper given by Professor Jagiellonian. It was really excellent, and he told us that he felt like Malinowski when he did some research on virtual reality. So it was really amazing for me to hear. Magdalena?
So that's something important. Maybe it's one more thing that he taught anthropologists that maybe the law is not so obvious as anthropologists thought at the time. And that there's, for example, now we can discover that for people like Tzotzil or Tzeltal who live in Chiapas in Mexico, something we can call law is something substantial, for example. It's something completely different from our idea of what the law is. So he said, law is not just this this system, what you think, what is obvious for you that it is. Yes. Yeah.
Thank you, Magdalena. And Federica, would you like to address some points that were highlighted by Professor Gadowska?
Yeah. Thank you very much for the points. Yeah, I want to actually continue what my colleagues already said. So exactly, the main methodological let's say innovation presented by Malinowski is this reconfiguration of the idea of law. So the westernization idea of law. So law, it is not only the written law, the law you can find in your codes, in your civil code and your penal code, in your European societies, or at least American society. Law is something more in the world, and this is a methodological, advice that can be useful even for today, because we live in a today, maybe more today than in Malinowski's time, in a multicultural world, and we have to deal with different dimension of laws, different dimension of social legal systems, and we have to try to find a solution between the conflicts between different legal perspective and different legal religious, for example, legal systems and so on. At least the first point of methodological innovation is something we have to deal with even today. So it is something to answer the question, what can we still learn? Exactly this. We have to learn that our idea of law is to be reframed, at least in a way. Then another point, when legal scholars tries to say that Malinowski can be a theoretical precursor of legal pluralism, we can maybe today try to see how his reflection of different legal system, multi-level legal system, can be applied again to our contemporary societies, in which again, within our European society, we have different level of laws and different conflicts between those levels. So just think about the national level, the European level, and so on. It is something very contemporary in Italy exactly today after yesterday elections. I want to be more serious now. There is a famous book in contemporary, recent, at least, legal philosophy, which is a book by Ronald Dworkin, entitled Taking Rights Seriously. Taking Rights Seriously. I am quite sure that reading Malinowski for us, I agree, we cannot find in Malinowski, think, a concrete definition, a concrete idea of law, concrete aspects, but his general idea can be used to, not to take rights seriously, but to take the law seriously, to rephrase Ronald Dworkin words. So in our contemporary society, unfortunately, I don't know honestly if it can be useful for the reflection on artificial intelligence, machine learning, and big data. I don't know, honestly. Maybe those are too complex problems, and I don't know if legal anthropology can fix those questions. And very briefly, how does the norm of reciprocity functions in civil law? The norm of reciprocity function in civil law in Malinowski's work, exactly when it talks about the gift exchanges, good exchanges. So as the idea of a contract, the exchange contract, and basically the main topic of Argonauts. In this sense, the norm of reciprocity can be used to define the civil law, what for us is the civil law, but not the penal law, because when in Crime and Custom it talks about the criminal aspect, let's say, of the law, there is not the idea of the norm of reciprocity, not the principle of the Latin formula "Daut des." So, very briefly, is this.
Okay, thank you, Federica. So I'm opening the floor for everyone. It is 1:30 p.m. I know. However, if you would like to ask some not questions, yes, but question, it's the right time. Okay, Deborah.
Hi, thank you for the papers. I'm not really asking a question, but I just want to share a sort of anecdotal insight, which is that when I first arrived at the LSE, the sort of living legacy of Malinowski's influence on sort of the study of law was there in the shape of Simon Roberts, who was still actually teaching at the time. He had, in fact, created a BA degree called Anthropology and Law, which is still running to this day, even though, in fact, the law department seems to be moving more and more in the way of black letter law and not really interested in socio-legal type issues. And at UCL, they have a special thing called the empirical legal studies, which seems to be sort of thought of in a lower way than like actual real black letter law. So I feel like it's a struggle to keep the Malinowskian tradition going, but certainly it was interesting to see as Simon Roberts, very sadly died a couple of years ago, at the end of his time there, he was doing studies basically in the spirit of legal pluralism on alternative dispute resolution, which his wife also was involved in. And he also wrote an interesting paper about how there was a court in London where the actual courtroom was never being used because there were always just people doing mediation between big companies and so on in little rooms within this building. So courts were increasingly being sidelined, and more you found sort of deals being struck in back rooms, and that was an interesting insight into the ongoing nature of what you might call legal pluralism.
Thank you very much, Deborah. Are there any questions online?
Yes.
Antonio.
Yes, please, there is one. Antonino Kolhani. No. Professor Kolhani would like to address some questions to the participants. I think not. Okay, so I had some question about the relation between Malinowski's theory of culture and theory of law. However, we are running out of time. So if you have some comments and questions to the presenters, you may ask them during the dinner, or you may email Federica Martiny. You may find her email address on the University of Pisa website. So thank you very much for the presenters. Yes. So. It's dinner time, yes, and the next sessions will start in about 1 hour, and I would like to remind you that the one session will take place here, and another one in the place when we will be eating dinner. So thank you one more time.
Thank you very much.
Thank you.
Thank you, Federica. It was a pleasure.
Looking at the subscription for the 10 minutes.